Mama's in the living room watching Judge Judy. I'm in the kitchen eating leftover sushi, and she goes, "Oh, girl, you gotta hear this one." A man was arrested for running a theme park, and when they said, "Where's your license?" he said, "My dog ate it." Oh, you can't make this shit up. Sometimes I wonder if life's just one big cosmic joke. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on a Prosecco, makes fun of all the weirdos, and then I hear her shout. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on a Prosecco, makes fun of all the weirdos, and then I hear her shout. Girl, you gotta hear this one. Mama loves to laugh at how absurd life is, says it's all a comedy and I'm her audience. And I love the way she makes fun of the world. She said, "You'll never guess who's with their girlfriend. It was a man who didn't get us out of the bed. He said, I've been through hell and now I need some help. You just can't make this shit up. You just can't make this shit up." Sometimes I wonder if life's just one big cosmic joke. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on a Prosecco, makes fun of all the weirdos, and then I hear her shout. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on a Prosecco, makes fun of all the weirdos, and then I hear her shout. Girl, you gotta hear this one.
Hey everybody, welcome back. If you've been following the Tyler Robinson case, you know that the documents stack up faster. Oh, I can't even describe it. However, there are some fantastic attorneys covering this in real time. Andrea Burkhart being the prime example of the one that I watch. However, that's if you're looking for minute-by-minute analysis, streaming all the hearings, all the documents, everything you got going on. However, this stream is not that. This stream is for the people who have jobs, families, responsibilities, and don't have 20 hours a week to sit in front of a computer and nitpick through the documents. Reading motions, reading court filings, I don't have time for it either. This case in the last few weeks has double-digit motions, and that's what we're doing today. Is our end of the month Tyler Robinson recap, where we just go over and hit the Cliff's notes on all the documents, maybe watch a couple of things in the hearing, not the complete 2-hour hearing. Ain't nobody got time for that on a Saturday afternoon. However, because I am disheveled on a Saturday, my hair's still wet, I just scarfed down an Annie Ann's pretzel dog for lunch, literally as the intro was still running. Oh, I have a friend of mine here who is a researcher extraordinaire who has been streaming hearings on this case on his Discord server and knows a hell of a lot more than me. Once again, he is another one of those people in my life that claims he is not as smart as he really is. Flash fan, how are you this afternoon?
I'm good. Hello, Tentacle Nation audience. I don't know.
And if you don't know, Flash fan is one of the brains behind this operation. He will hide with his modly status. He is busy most of the time when I am streaming, so he's not always here. But we are in almost constant contact. I talk to him at least once a day, once every other day, if nothing else, to just say hi. Because Flash fan is a research genius. Just saying. He will tell you he's not. He's another one of those people in my life that will say they're, when I call them an expert in certain areas, and they will say, I'm not an expert. He is. He's lying to you.
I even told her, I'm like, you should, since I'm not here, you should probably take me away, take my lunch away. She was like, overruled.
Bullshit. Yeah. Bullshit. Okay. Flash fan has been with me since before I started my channel, asking me when I was going to start my channel. So, with that, he will never lose his wrench. He is my little brother. Oh, you are like family to me. And yes, Queen Lady Wolf, everybody, hey Queen, how are you? Everybody needs a Flash fan on their team. Everybody needs a Flash fan in their life. And now talking about Flash fan, how are you and what are you up to lately? What's going on in your world?
With streaming, haven't really been streaming much. This week on Friday, I picked up the case going on in South Carolina, where convenience store owner, I don't know if this guy, the victim was African American, 14 years old, walks into a convenience store, accused of stealing 4 water bottles, takes 4 water bottles out the freezer, puts them back, and the owners chase him, and the owner accused him and analyze him. So he's on trial for that now.
Wow, what a way to escalate things. I mean, I know crimes are crimes and things, but like there's a way to not escalate situations into a complete shit show, for lack of a better terminology.
All because they claim that he had a weapon, so they're like, we're gonna chase him. I'm like, I'm sorry, if I'm in y'all position, I'm not risking getting unalive by chasing somebody that potentially has a weapon.
No, and also when you chase somebody, you lose that self-defense argument.
And that's exactly what they're arguing. I'm like, yeah, okay, good luck with that one.
Yeah, you lose when you are, because you are now the aggressor. It's all weird, but you have looked at a lot of these documents and seen things, and you streamed this last hearing.
Well, I didn't get a chance to stream, but I know the gist of what they were arguing. I didn't read the whole motion because, man, Utahns, they write a lot. They write a lot.
I swear they get paid by the word. Before we get started with that, Hung Hero, thank you for being a member for 20 months. 20 months, Jeebus. Also, Hathcock. Hugh Hathcock was a defendant in a lawsuit with Billy Napier, the former University of Florida football coach. I've no longer covered that case because the documents are sealed. So there's no point in kind of trying to, there's no new information. So there's nothing for me to cover because everything is sealed. And yeah, but my chat makes fun of me, specifically Roy, Hung Hero, and a couple others. And I also tell them that if they ever want me to say that, they have to put it in a super chat or a member chat. So
I've forgotten about that.
Yeah, it's almost a 2-year-old situation. Yeah. And Hung Hero, thank you for the 20 gifted Squid Pro Quo memberships. Oh my goodness. And we will be doing Tuesday, 2 o'clock-ish, the next installment of Timu Law School. Because that's always fun to literally make fun of lawyers and the incompetence of people who are supposed to be smarter than us. And Mspire, thanks for being a member for 16 months. Much love to you, Squid. Much love to you as well. How are you? And I hope you are doing well. Are you sure it's sealed and not walrused? Not going there. Not going there. And hey, Spawn Trooper, how are you? All right. So somebody has asked me why I didn't start a Tyler Robinson case section on my Discord. There are reasons. Mainly, Snipe Hunter, thanks for being a member for 6 months. The sealed, it's Hath, but they make fun of my accent and the way I say it. Hathcock. Yes, but everybody makes fun of me.
You know, I never noticed your Wisconsin accent. I guess I just have to pay close attention.
It comes and goes. It's certain words. It's blatantly obvious. Yeah, it's also I did give away all my memberships for this month. Thank you for that reminder. Getting back to the topic at hand, there are reasons why I haven't made a document section for Tyler Robinson in my Discord server. It's because these documents are paid for, but I am getting these documents from Andrea Burkhart's Substack. With that being said, she has paid for each of these individual documents. I have paid for her Substack for a year. But because she has bought these and she has taken the time to go purchase them, download them, upload them to her Substack, I don't feel ethically right reposting them when I did not do the work to obtain them. So if anybody, there's reasons why I haven't. I did not respond to that individual's request because I just wanted to make it, I thought it would be right to say to the chat as a whole why I don't do it. It's
dedication purchasing these because they, I don't know what they cost about a page, but that's
I think it was like, when I looked at it, I think it was like $40 a month to get access to the system. I'm not sure if that's accurate or not, but because I am not the one going through the work of obtaining them from the state of Utah, I do not feel right reposting them to other people. I will talk about them, I will show them, but Andrea Burkhart is the one who deserves the credit. And if you want the actual documents for yourself, go and give her Substack some love and get them there.
Yeah, she got dedication to those cases. She covered those type cases, Robinson and Delphi and stuff.
Yes, and she also is a lawyer, and I am not. So it's, however, this is all the documents from the case. We are up to 558 docket entries. Not all of those are clickable documents. Some are just, return of electronic notification. However, 558 documents in a case that's, yeah.
And it's important to note that 500 document the case that hasn't made it to the trial stage yet. He ain't even had his preliminary hearing yet.
Yeah, that's also like, yeah. That's what is being argued in a lot of these documents is the preliminary hearing. Yeah, very honorable when we give a thanks to that person or creator with permission. Yeah, she has given me permission by me paying for her Substack to have access to these documents. She has not given me permission to post them on my Discord, and I just feel some sort of way about that. You know what I mean? Like, yeah. If anything gives me the ick, ethically, I just try to avoid it. Like, it may not be unethical. However, if it gives me the ick, I just avoid it. Because that way I don't have any problems. Yeah. That way I don't have people getting mad at me for shit.
Nobody be like, she stole this and she stole that.
Yeah, I don't, nope. Like, I don't, if it gives me the ick, I just don't do it. But looking at her Substack, this is all May started up here. Like, this is May. Motion in limine to close portions of preliminary hearing and seal particular exhibits. TLDR with the defense, they want to seal everything. They think, and they have this mindset that closing or that having anything public is discriminatory, is costing him a fair trial. It's like, no, that's transparency when you're accused of a crime.
And the roles are reversed. It's usually the state, the government, who usually opposes trials and stuff being open to the public. This time it's the defense, so that's the first. Usually it's the state, like, no cameras.
Snipe Hunter has summed up the entire case in one sentence. Let me give my synopsis. Lawyer Nestor sucks. Yes, this is Utah, and if anybody followed Corey Richins, I didn't watch all of Corey Richins because I just like I don't have the time to stream trials. I also don't have the time to watch trials all day long.
I didn't watch it. It was like 6 weeks long. I'm like, yeah.
that's why I'm in and out. Like, I know people's names, I know situations, I know the general gist of what happened, but I can't tell you individuals' testimonies because I did not watch the entire thing because I just don't like 3-year-old. Maybe when my child is in school and I have like time to listen while I'm doing other things that are monotonous, like dishes and cleaning floors and stuff.
Yeah.
However,
Which makes me think when this goes to trial, this is going to be O.J. Simpson level length. I have a feeling this trial is going to be super duper long.
yeah, this is going based on the fact that it's been almost a year.
Yeah.
And we haven't
in September, and it's almost July.
We haven't gotten even to the preliminary hearing yet. And yes, if you are new to what is actually going on in the documents and not just the headlines, we have not gotten to the preliminary hearing yet. For most cases, the preliminary hearing is like a month after the arraignment.
I want to say like 60 to 90 days. I think speedy trial, you don't wait that is 90 days. And I think the preliminary 30 or 60 days after the indictment.
It's just, there's just so, like, I don't know. And there's so many rumors around this case too. Like, because he was a public figure, people are like the conspiracy theories and the amount of people, and this has irked me from the very beginning. And Outpost Nerd, it's good to see you because you were one of the people who was on my stream when I did my like reaction. It's one of those simple things of how many people are making opinions and comments and writing articles who have never watched a trial in their entire life, who have never stepped foot in a courtroom in their entire life, have never seen the inside of a courtroom, and are now like internet experts in what's going on. People who don't have degrees in psychology are all of a sudden experts on how people should act when they are public figures, after people are unalived in front of them. Like,
so I'm not gonna lie. Before I watched trial, I had that mindset. Not the mindset that like public figure, he deserved it. But I did have the mindset of like most people have, where if the state charged somebody, oh, he must be guilty, they won't bring charges. Now I know better, but I used to have that mindset.
Yeah, but watching trials, you learn.
Yeah. Like,
we're not lawyers, but when you watch things, you learn that life is a lot more complicated than he did it or he didn't. Yeah. Like, there's a lot of paperwork. There's a lot of time. There's a lot of, yes, you get the internet weapons after, I went to a range one time.
So does a lot of other people.
I shot a freedom seed thrower one time. I'm an internet expert on PQs. I love my Second Amendment, and I don't even claim to be an expert. I have certain exhibits that I've showed to show, to compare like size difference, and when we're talking about bullet fragments, what we're actually talking about, how small of fragments we're actually talking about. However, I don't ever claim to be an expert in ballistics. No, like, not even close. Not even close.
That's why when I had
the knowledge I do have, I got from Mr. Squid.
That's like when I had friends and people from church or just people family like, you watch trials, so you must know what this and all. They're like, no, I don't. Just because I watched over a whole lot of trials, like over 100 trials, don't mean I know everything.
the nicknames. Oh my god! But yes, and it's not even that they're lying, because I don't necessarily think they're lying. I think they're taking half truths and things that could, you know what I mean, like without context, and putting things out there without context, and making it, when you put stuff out there without context, and then people make assumptions, people who don't know make assumptions, and then other people make assumptions, other people talk about it. It's a telephone game. The telephone game with the internet is a very dangerous game.
And that's what I like. I don't know if you was putting on playing that hearing, but when the judge denied the motion to exclude cameras initially, they still trying with this motion to seal portion of the preliminary hearing. But I like to say it, like, when you put stuff on the news media, you have where people, when they write articles or whatever, and they put clips on just the news people, reporters talking, they can spread misinformation. But you have the cameras in the courtroom, they can't spread that misinformation because they're seeing what's happening in court in real time.
Hey, Philip, why do these people just keep on paperwork? It's nuts. This case is less than a year old and has 548 docket entries. Not all of those are paperwork, but
they do like to write.
They do like to write. I swear they do for the word. Like, this is what makes people hate. Like, there are certain things that I say, like, not all lawyers are bad people. My friend who passed away, good person, really good lawyer. There's certain people that give one bad apple spoils the bunch, so to speak. And when you see shit like Kathy Nestor and just the ridiculous arguments that people try to make, that's where I'm like, this is what gives people, this is why people don't like lawyers. This is why lawyers appear shady, because this is what makes the news. The good lawyers who do their job, who help people, who are humble about what they do, don't ever get the credit. All you see is the people who want media attention, or the lawyers that know they're going to get paid whether they have a really good argument or not, because their clients don't know any better. Like, it irks me, because I'm like, and this is one of the things I was talking to someone this morning, and she was like, what do you cover? And I was like, I make fun of lawyers. She goes, what do you mean by that? And I was like, well, I don't make fun of all lawyers, but when a lawyer writes something stupid in a motion, I'm going to be snarky about it. Like, I'm going to make sure that everybody freaking knows. And when a lawyer writes a stupid motion or has a stupid case, because we can't hold people accountable for being good at their job if we don't know what their job is. Public officials, lawyers, doctors, if we don't know what their job actually entails, how can we hold them accountable to doing their job?
Yeah.
And that's why we look at stuff and we're like, I'm no lawyer, but that sounds shady as shit.
Like Sarah Boone's motion for snacks in the courtroom.
Motion for Pop-Tarts. The Pop-Tart motion will never go away. There are just some things that you can never, like, that my dog stepped on a bee. Elaine's What If Anything from Johnny Depp. Like, there's just certain things that will just not.
People always say she invented that. What if anything? I'm like, nah, lawyers always use that. They use that stuff back in the O.J. Simpson case. Johnny Cochran used what if any.
Yeah, he just used it for, like, he just used it to. Okay, she used it to an excess where it was like, she just used it to a point where she was trying to ask leading questions.
Yeah.
By using the phrase, what if anything?
Yeah. Trying to get a quick walk around it so it won't get ejected.
So I did follow this woman on, so stupid case, like a woman who had her hand amputated being accused of holding a cell phone in it. Yeah. So there was a woman I follow on Instagram. I cannot remember her name offhand, but if I could see her face, she got pulled over in Florida. I believe it was in Florida.
Oh, well,
or and the cop specifically said, holding a cell phone in your right hand. She sticks up her right arm. She does not have a right hand.
Oh. Wow.
Her case was dismissed. She still went to court because she's like, in her latest video that I saw, she was like, I don't trust things, so I just went anyway. It was dismissed due to a lack of evidence.
Yeah.
Yeah.
That would do it.
Yeah. It's like, you just look at shit and it was like, and if he would not have specifically said right hand, okay, maybe it would have gone through. She would have had to prove her case. But he specifically on the body cam said right hand.
Yeah, it's so many cases that are brought. This one was the defendant's fault. He sued a taco shop in not North Carolina, New York. I think New York City. He sued the taco shop because the sauce was too spicy. The judge dismissed it. I'm like, yeah, that's stupid. Because it's too spicy.
Well, I remember Panera. There was a woman who sued Panera, or a woman's family who sued Panera because she had that that lemonade, that like highly caffeinated lemonade,
Oh man.
and had a heart condition, had the lemonade, and passed away.
Oh.
And it was like, well, she should have known.
Not trying to victim blame, but you knew you had this condition. Why would you get it?
Yeah, it's a. He backtracked, but she like in the body cam said like, you want to just call this a day? And he said no.
Yeah, that's
So, yeah. It was South Florida. Yeah. I thought it was Florida, but once again, it's kind of one of those things, one of those details that escapes my mind when I'm talking about a story that is not actively in front of me. And I don't like to. So I said, I think it's in Florida, but like, don't necessarily quote me 100% because I don't know for sure. Or I don't remember for sure. And hey, Magic Angel, how are you? Yeah, slightly off balance. Thank you. I follow her on Instagram and she comes up all the time.
I've heard
you know me. I'm cognitively impaired. So like remembering people's names. I can barely remember people's names that I talk about all the time. Like someone asked me what Lips' name was, who was Lips, and I couldn't remember the damn woman's name, even though I've read her name 100 times in freaking legal filings. I could not remember the woman's name. Like that's how much like details that aren't important to me.
My aunt's like that, but hers is slightly different. She forgets her own birthday and stuff like that. She forget my birthday. I was like, okay.
The official reason filed was lack of evidence. Yeah. At least you don't forget you have a live. Yeah, because I get anxious about being late. Hence why I appear disheveled sometimes, because I'm rushing because I don't want to be late. Because the biggest thing for me is being late to anything. And when I'm rushing, like I hate changing the time of streams because I'm running late. So I rush, and then I look disheveled as hell because I'm like trying to do 800 things at once.
Your real fan ain't gonna judge for that. We all.
Huh?
I said your real fan ain't gonna judge for that. We all run late sometimes and stuff like that.
It's not just YouTube though. It's like in life in general. Like even being late to the gym for like a 12 o'clock class, if I'm there at 12:01, I'm rushing to get there. Even though it's like if you show up a couple minutes late, it's totally fine.
Yeah.
It's my biggest yeah. Anyway, getting back to this, we're not going to go through every one of these documents because the state has filed motions for what evidence they're going to have. There is a non-public information of dependent status report. I just find that interesting that they're hiding some things. But we are going to look at this order to appear first. And I don't have these saved like I should. This was just an order to appear for a May 8th hearing. We are going to look at that. But I like to actually just look at the orders so people can see that these things are put in orders.
Yep.
Like this is one of the reasons that even though it's just an order from the judge, we still look at it because it lets people who may not watch legal, may not be law tube viewers or anything like that, see that how these things actually work. Like everything is put in writing. If it's not put in writing by someone, whether it be a lawyer, the judge, or the clerk, it don't matter.
Yeah, no, I hear people say something about a case, and I go look. If it's like a 40 case or something, I can get document free. They'll say something, and I don't look. I'm like, that's not accurate.
That's
That's not an emotional filing.
I was like, that's why I always like the documents, because the documents tell the story. People in the media like to talk about emotion and this and that. It's like, well, what are the actual facts? Because the facts and how you feel about the case don't always match.
Yeah.
And that's where the difficulty comes in, is we have to separate the facts from how I feel about things. Because feelings can change minute to minute. Facts take time. And Hung Hero, thank you for the $2 super chat. Save my name. Okay, my joke fell short. And everybody, thank you for the super chats and the love and the sharing my stream and stuff like that, because we are having to replace our air conditioning unit. Oh yeah, yesterday was a
how hot it get in Georgia, from what I understand, in the summer. Ooh, yeah, y'all gonna need an air conditioner.
Yeah. Say Hung Hero's name, Hung Hero. I mean, yeah, I got thoughts on that, but I can't say them on YouTube. But he knows. I'll talk to him later. I have a joke with that, but it's kind of not YouTube appropriate. I have air conditioning. We just have to replace ours because, for reasons, when this house was built, people sucked. Whoever the company that installed this air conditioner are giant assholes, and they did it the cheapest way possible. And it's not going. Yeah, it's just a thing. So I appreciate everybody sharing my stream, hitting that like button, helping me increase my subscriber count so that I can help. Because I am not the breadwinner in my family, but I'm trying. And I can't do it.
Let's get our favorite Amari to 5 million subs. Let's get her chat moving faster than Emily D. Baker's.
That's never going to happen. Yeah. Destiny's Child. Wow. You just showed your age with that one. All right. So this was for a May 8th hearing. No big deal.
Yeah, I think that's the judge's ruling on the cameras.
Yeah, I think so too. So, yeah, Pacer, truck, HVAC, banana ear. Yeah, it's been banana fun. It's just it's a thing. Like, usually I always feel bad when I'm like, hit the like, subscribe, make sure you share this stream. But I really need it now, y'all. I really do.
People always talking about YouTube with the grifted and you grifted on. Isn't that what you're supposed to do with YouTube?
That is kind of true. And I have to shut some of these shut down some of these programs that I have running so I can keep my brain. You know, when you close tabs and you're like, you gotta, closing the tabs also helps close the tabs on your brain because you can keep life straight.
Yeah, that and when there's a lot of tabs open, you trying to look for something, you're like, nope, that's not it. Nope, that's not it.
So yeah, it's like when you go and show everything and you have 1, 2, 3, 4, 5, 6 windows open, and it's like, this is not even necessary for this stream. Why is it open? This is not, and it's confusing. Like, take the HVAC installer to court so we can watch it comment. If we can, we will. I'm not saying that we are, but it's not out of the realm of possibilities at this particular point in time, because if we can even recover a few $1,000s of the 15, we are, yeah. By the way, Jay tried the AC for Squid Grit. Oh my God. That doesn't surprise me. People are like, yeah, Jay will grift for you, Jay. Yeah, for him. For him. $2 challenge placed yesterday is falling short. Gail, it was not. Somebody sent me a $500 Ko-fi yesterday. Yeah, I didn't know what to say, and I about near cried. I was thinking that when they sent me a message that they were going to ask for a refund because it was an accident.
There's generally some nice people out there. I know that don't count.
There are some amazing people in this world. Amazing people that I don't deserve to have support me, but do anyway. And I don't know what I did to deserve it, but I'm not going to complain. Hong Hero, thanks for the $5 super chat. You're from Wisconsin. Channel your inner quarter. No. If you have not seen that, definitely go over to Cody Camelot 331. Check out his coverage of the quartering crash out. Because he had Sydney Watson on his channel.
Oh wow.
Sydney Watson used to be on or have a company with quartering. So that just a thing. Yeah. Not yet. I know a lawyer from Connecticut that's cheap. I'll pass.
I know somebody keeps saying Connecticut in general.
Oh my goodness. There was a motion in limine filed on 5/6. Let's see. State's response, this one. Because I did not go through, and I did download all these, but because she's been working so hard, they are all named the same. So I'm just re-downloading them again because I haven't changed the names. I just have them all in one folder, and instead of opening things up.
Yeah, I know when I grab motions and I save it to my Acrobat so I could send it over to you, and it'd be like some type of like contest, so you got to change the name. I'm like, these are some long motion names. I'm just shortening these because
2K views on yesterday. I didn't look. I honestly didn't look. Let me look now. 195 likes on yesterday's video, and surprisingly enough, not one dislike. Which means I know 3 people who didn't watch it.
Oh.
Yeah. Hung Hero's favorite.
Now they don't say that in Utah, I don't think.
But guess what? I do have a dislike on this stream. 17 likes and 1 dislike.
Somebody like, yeah, Tyler Robinson.
No, somebody either doesn't like that I am covering this at all, or they don't like the fact that I am not a lawyer and I am reading legal documents. So that's generally how it works because I'm not a lawyer.
There's a small section of YouTube that's not lawyers that reads. There's somebody I watch now and they read documents from Ohio, the American Idol case. She ain't no lawyer.
Yeah. It's not even about being a lawyer. It's about having the critical thinking skills and understanding the situation at hand. And I'm sorry, it's not that I don't like lawyers, but I think certain people are in this club because they all have the same degree. They have, you gravitate towards people who are like you, yeah, and who have the same education
that's
same background.
That's one of the reasons why I stopped watching LawTube a couple years ago. Different fact that LawTube is, but I was like, I want to find people like me. I'm watching all these lawyers.
Yeah, and it's just one of those things of like, I just have this mindset that in order to keep people it's not that I don't trust lawyers because there are some great ones out there. It's just one of those situations of other people need to know that we can access these documents too. We don't need to rely on lawyers to read them and figure out how to understand them. We don't need to rely on lawyers to figure out how to go to Congress's website and read the laws that are being pushed out to us. We don't need, you don't need a legal degree to read and have critical thinking skills. There are some of the smartest people in the world who didn't even go to college. So my goal with this is to let the average person know that it is okay to read legal documents, and in order to hold the people who write this crap to the feet to the fire is we have to actually read it. Otherwise, we think they're doing a great job when they may not be. It's,
It's important for everyday normal people to know their rights and laws, and so people can't get away. If they ever get in trouble or something happen, they know what to do so they don't get railroaded and stuff like that.
And sometimes I'm convinced that people cover for each other. So it's I'm convinced people have like cover for each other, not intentionally, but and sometimes, and the average person reading it, like, we're the jury.
Yeah.
So if we look at stuff, we're the jury. We're the average person who would be on a jury.
Yeah. I would love to be on a jury. Unfortunately, I can't because of vision impairment, but I would love to be on a jury.
I got out of jury duty the last time I was up for it just because I literally had nobody to watch my child.
Yeah, that would do it. That's a hardship.
Yeah. Trust me, the clerk of court was like, or when I gave my paperwork, whoever was in there was like, I'll babysit. And I was like, if I knew you, possibly. However, like, I also don't know what they do if they said, what do you do for a living? I read legal documents on the internet and make fun of lawyers.
Yeah, that'd be like, yeah, Your Honor, motion to strike this.
Like, no, she used that excuse to get out of a deposition, not jury duty. If I had a deposition, I'd be like going to care.com and, figuring something out. Or if I had a deposition, I'm sure that like Mr. Squid would take the day off, kind of a situation. But jury duty is different, Yeah,
the case out of Florida where they tried to pose a witness and she refused to answer questions, so they trying to get a second one and order her to answer questions because apparently she was dodging questions and just saying, if you want me to answer the question, you got to tell the judge to tell me to do it. I'm like, God damn.
Why people? I don't understand why people got to be so difficult.
I mean, I understand why she's mad because she's the victim's wife. So, but I'm like, you still gotta ask the question.
But Jeff's account in the chat, Jeff's son, and Jeff. I don't know if you're with him, but Jeff and family, how are you guys? I hope you are doing well. As well as having a different opinion as to what outcomes should be in different cases. It's okay. It's true. Like, it's just been on 13 juries, boring stuff till the fireworks go off. Yeah. And if you do watch trials all day, it is kind of boring, which is one of the reasons that I watch things on speed play when I do trial watch. We watch it at 1.5 speed and we skip the sidebars and the judge just
especially like this case. Portion of this case will be boring because they got like Discord logs and text messages. Digital evidence crap is always boring.
Text messages will be fun to see, but like, I don't care about the metadata of Discord. But this one, defendant Tyler Jaden Robinson's motion in limine to preclude the utilization of Article 1, Section 12 of the Utah Constitution and Rule 1102 of the Rules of Evidence to sanction the admissibility of hearsay evidence to establish probable cause at a preliminary hearing.
That's what I don't like about Utah. Why can't you just say motion to preclude hearsay?
Well, that's what I don't like about lawyers and the way laws are written. And laws are written most of the time by lawyers.
Yeah.
You can't just use plain language text. They have to write it in a way that's just so And like I said, this comes from me, my medical background. And when I write notes, it's patient did this many times with this for this purpose. Like there's no fluff because time is money. I have patient note, patient. And hospitals do not like paying you overtime to write notes. You've got to write quick. That's why shorthand exists. I just like things here. I don't need all the bullshit to go with it. I just need the who, what, and why, and how many times. So, my but with respect to confrontation and cross-examinations of witnesses, Supreme Court has held that almost every setting where important decisions turn on question of fact, due process requires an opportunity to contact, confront, cross-examine adverse witnesses. I get that, but this is a preliminary hearing. This is only to establish probable cause. This is not the damn trial.
I'm like, isn't hearsay admissible? Because I remember in Tennessee, Austin Drummond was one of the reasons why he tried to fire the attorney, which that motion was denied, his pro se motion, because he was trying to waive his penalty phase if he convicted. I'm like, yeah, you don't need to go pro se. But he they wouldn't ask hearsay and stuff, or they would ask hearsay at preliminary hearing. They wouldn't ask about motive, and just like at the preliminary hearing, that stuff it's a gold bar, so some of that stuff can come in. It's not your attorney's fault.
Well, and here's the thing. According to the everybody's favorite rules of or everybody's favorite law school for dummies, Cornell's law school for everybody. You just need maybe for probable cause hearing, maybe based upon hearsay. May. Not necessarily is, but may. Which it seems like they're just trying to delay. That's all I'm seeing in a lot of these documents. Because I'm sorry, not even the documents that in cases where people I know are trying to delay have 500 documents.
Yeah, no.
Like, not even cases with multiple defendants have 500 documents.
Google say in most jurisdictions, hearsay is generally allowed to establish probable cause at a preliminary hearing, but there are strict limitations and variations depending on whether you are in federal court or a specific state. So some is allowed. So I don't know what they're trying to exclude from that, but.
And I saw that you DM'd me, and I saw that a case. I just haven't had the time to read it, but that should be an interesting one. That's another.
They should televise some of those cases, those civil cases and medical malpractice cases and stuff like that. They should televise more of those.
Medical malpractice is an interesting one. We still have to rehash all the medical fraud cases that I had covered when that the DOJ did their investigation in 2025. And I started covering those cases. I have to do updates on some of those. So, because medical.
I think the Take Care Maya, isn't that going back to retrial?
Yeah, and there's also been other stuff in there. There's been documents that Lawyer covered that explain a little bit more about the split between lawyers.
Ooh.
And I'm not touching that drama with a 10-foot pole. I covered the fact that Nick Whitney left the practice and all that, but there's some accusations against Greg Anderson that they would be dramatic and they would get me views and probably a shit ton of ad revenue. However, I'm very hesitant to even
it's kind of like a Hill situation. It brings all these people, but it also brings a lot of trolls too, probably.
No, it's not even that. It's a topic that I don't want to. It's a topic that I don't want to cover. I have covered accusations of misconduct like this in the past, but from people that I'm not familiar with, that I don't have 6 degrees of separation with. Oh, I don't know. I don't know. I have strong feelings about it, and I'm afraid that like I would yeet myself off YouTube by giving my opinions.
Yeah.
Yeah. Have a good one. Oh no, you tore your rotator cuff. Goodness. Yeah, I just yeah, it's a thing. But getting back to the lawyers at hand. Oh, Kathy Nestor and company. And
Now,
I swear they're only using Kathy Nestor because she's a local attorney.
I'm more interested to see what Michael Burke would do because he was Lyle Menendez's attorney back in his first trial back in 1993. So I'm more
interested how well that went.
Well, no, that trial he got him a mistrial. The second trial with different attorneys, but in the first trial he got him a mistrial.
And I wonder, comparing the two, if they peppered the court with documents to cause chaos and confusion. Because this is 538 docket entries in less than a year.
Yeah, before he's even bound over for trial, he's not even in the trial court stage yet. I don't know if it's going to be the same judge. I hope it's the same judge that this is the same judge that handles the trial because he's been good at following media wide, and I'm not confident in some of the other Utah judges.
Yeah, I'm cutting back on crap cases and stuff I don't want to cover. Yeah, it's I would love to cover it, but I would afraid I'd get my channel yeeted because of my opinions. You know, April represents third-party insurance companies, so the entire case was challenging the worker's claim. During deposition, she discovered fraudulent filings by the employer. Oh, I hate fraud. No matter if it's like, I hate fraud. I just, from the top to the bottom, I just.
Yeah, I'm not big on that stuff. That's scam and stuff. Cause I have been scammed. So yeah,
I just hate all forms of fraud.
Yeah,
because there's people who work their asses off and get nowhere, and then there's people who don't work at all and have everything, and it's like, yeah, I hate fraud. It lights a fire under my ass to like, so it's they just want all hearsay. I don't know, this motion, every motion from the defense, and this is one of the reasons that I don't read them word for word on a stream anymore, is because Kathy Nestor gives me a migraine.
It's so long. She's just so wordy. Like, they got a motion to continue the preliminary hearing. Yeah, most of the preliminary hearing, and she works like all these. I'm like, all you have to say is why you need a continuance, and that's it. What are you doing?
It violate Mr. Robinson's Sixth Amendment right to the effective assistance of counsel. No, having you as an attorney violates his right to an effective assistance of counsel.
The crazy part is I used to be a fan of defense attorneys. I don't know why I stand no more with that.
So the case law she cites, plainly the guiding hand of counsel at the preliminary hearing is essential to protect the indigent accused. How is he indigent if he has 4 or 5 lawyers that are all?
So technically Nestor is a public defender. I don't know if these other people are public defenders, but
they are not.
Oh, well. Yeah, I know Michael Burt isn't because he's an attorney in California, but I didn't know
they are not. Wow. I just.
So he's a public defender and all these. How the heck is he paying for these people?
How are you indigent? And that's what I don't that's one of the many inconsistencies with the defense in this case.
Yeah.
And why California? Why did you get California attorneys? You don't live in California.
And I don't think we haven't seen Michael Burt in years. I don't know if California don't tell about the cases, but we haven't seen him nationally in years, decades.
I don't. Snipe taunts me all the time. You know. But I also have Flashhand with me, and we are not reading these documents word for word. We are discussing this case and everything that's happened this month and what we think about this case, because I haven't talked about this case all month because for reasons such as this, like, who has the time to read through on a stream? Like, I'm not gonna lie, I have Speechify read these documents to me while I'm working and doing other things so that I can hear them, and then I go back and I like look at the parts that I feel like I missed or things like that, because that way it's like listening to an audiobook but a court document.
Yeah.
Because that's the only way that I can get through all these documents. Speechify on my phone.
Yeah, these documents, I tried reading them. I'm like, I can't do it. I had to skim them, like, okay, what are they talking about? I'm like, okay.
I feel like she brings up Sixth Amendment and his right to effective counsel every chance she gets. It's like their only fallback.
Yeah.
Defense counsels have repeatedly been found ineffective by both state and federal courts for failing to effectively utilize the essential tool of cross-examination. It's a preliminary hearing.
You can cross-examine, and nobody's stopping you from cross-examining. What you trying to say?
I'm like, what is she like? I don't understand her argument. Like, I really don't. Like,
It'd be ineffective, but you decide to be like, no questions, Your Honor. I don't.
If she's like saying, I wouldn't be effective if I can't do this. If they bring in hearsay, I can't affect.
It's a preliminary hearing. There's no jury present.
Yeah, it's.
A judge is not going to consider, if it's something improper, a judge isn't going to consider it. It's a judge, it's not a jury.
And I feel like she brings up so much case law, and the failure to impeach the credibility of key witnesses with known false testimony is egregious error. What does that have to do with the preliminary hearing and hearsay?
You technically don't have to even do credit. I mean, attorneys don't sure do it in preliminary hearing, but you don't have to do it. You're just trying to learn. Usually, defense attorneys just trying to learn the evidence that the state has so they can prepare, because it's a no bar to get bound up with a trial. Most times, it's not going to get dismissed at a preliminary hearing.
Article 1, Section 12, Rule 1102 violate Mr. Robinson's 14th Amendment rights to procedural due process and equal protection. Due process clause she brings up. You have a problem with the Constitution of the state of Utah.
It seems like this isn't a Tyler Robinson issue. This is an issue that needs to be brought before legislators and stuff like that.
And this is my thing. This is my thing. If you all of a sudden have an issue with this article of the Utah Constitution, how many other cases have you tried that are similar where you haven't brought this up? Did she bring this up in the Corey Richards trial? Probably not.
That makes me, I'm going to go back to see what she's like to watch some of that.
Oh my God. She's insufferable. Like, I can't. She was one of the reasons, like, thank God Mo was covering that, because that was the only reason I was able to tolerate that, was because of Mo and her humor.
Because way back when the case first started, I remember you saying he had some great attorneys that skipped to like 10 months later, like, yeah.
But she's like, I swear she gets paid by the word. It's case law, case law. And I don't even know if she's citing these cases correctly. I just, the criminally accused share many of the same liberty interests as the criminally convicted. Clearly, the criminally accused retained an interest in freedom from prosecution based on erroneous information. It's a preliminary hearing. It's like she thinks the preliminary hearing is judge, jury, and executioner.
What I think she's doing is she's fighting as if her life is also on the line, which you don't have to fight that hard. It's a preliminary hearing.
Preliminary hearing. So same thing with the due process clause, because it establishes an unconstitutional mandatory presumption of reliability of an overbroad range of hearsay evidence. You have a problem with the Utah Constitution. How many other preliminary hearings? This is the thing. If you are doing this, how many other preliminary hearings have you brought up where you are saying the same exact thing. I can guarantee you she's never used this before.
Because well, no, I can't use the Corey Richards preliminary because Corey Richards had a different attorney. I think she got nested like a year or two ago.
I
think the original attorney conflicted out with somebody other.
One of those Supreme Court ruled that mandatory presumptions are unconstitutional because they shift the burden of persuasion to the accused. It's a preliminary hearing. You're not in front of a jury. The judge just needs probable cause. It's
kind of like how with certain bench trials they have, and they object like hearsay. Like it doesn't matter if the judge deciding the case. The judge knows the law. The judge is going to consider improper hearsay.
It's so. She mentions Utah Code 41, but this all refers to a trial, in my opinion. Like I said, but like in any action or proceeding in which the material to prove that a person was operating in actual physical control of a vehicle. Talking about DUIs. What?
I want to see how much he's been an attorney.
She makes me angry, like with the way she writes. Hey John, how are you? Like I know, like this, we're only on page 16. Like I haven't actually seen an argument that makes any sense from her yet. So
he has been trying complex cases in the federal and state court for over 30 years. Having begun her practice in 1992. So why okay.
So once again, she applies this like it's the trial. In my opinion, she's applying these like the preliminary hearing is the same thing as the trial.
Yeah.
And it's not. Article 112 violate Mr. Robinson's 8th Amendment right to be free from cruel and unusual punishment. In capital proceedings, generally this court has demanded that fact-finding procedures aspire to a heightened standard of reliability. In the trial,
you talking about penalty phase. This isn't penalty phase. Never got there yet.
In the trial, this isn't.
She didn't even know she's going to be a penalty phase yet. If your client is innocent, they shouldn't even get to know penalty phase.
No, she didn't accidentally do anything. This is intentional because she
always does that. That's nothing.
Yeah. Since Mr. Robinson is only exposed to a potential sentence of death if this court makes certain findings in his preliminary hearing based upon evidence, that he's going to trial?
That's not how that works. A judge doesn't even decide death. That's the jury for the penalty phase.
A preliminary hearing without any meaningful adversarial testing of a significant portion of the evidence the state intends to proffer. It's not a trial. It's a
How has she been attorney since 1992? I don't know.
Now we know why she's a public defender. No offense to any public defenders. Andrea Burkhart is a public defender. At least she was.
I thought she would.
Steve Gosney has been a public defender. No offense to public defenders. But once again, she's the reason public defenders get a bad name.
Yeah.
Like it's findings in the no, you're Rule 1102 here sanctions a preliminary hearing without any meaningful adversarial testing of a significant portion of the evidence. This is not a trial. Like I just see this as where it's like we gotta, and this was not. I don't think this was written by Kathy Nestor, but it,
No, I think most of the filings are by. I think most of the filings are by Novak. I think that's how you pronounce his name.
Article 1, Section 12, Rule 1102 violate the Confrontation Clause of the Sixth Amendment. like, the majority of Supreme Court confrontation clause jurisprudence have focused on how the rights applies at trial. However, the court right to counsel's analysis in Coleman demonstrates this trial right extends beyond the trial itself. Okay? Fair. The court expressly acknowledged that that at a preliminary hearing, the importance of the issue to both state and the accused justifies the presentation of witnesses and full exploration of their testimony. So cross-examine them. Kathy Nestor, Richard Novak, Michael Burt, and Stacey Visser. 4 lawyers. Four lawyers. Sometimes you just look at shit and you're just like, what? Just what? Just why? So here's the response. So this is the state's response. Defendant's motion limited to close the portions of the preliminary hearing, which would be inadmissible at trial. So this is, and this is still 11 pages. So this is, yeah.
Yeah, it's just a Utah thing. They write lengthy stuff. That's not her issue. Everybody Utah.
And I just have to take this away for 1 second because I just have to make sure of something.
All you think about that case? I'm hoping somebody picks it up, and I'm hoping the media picks it up. What's the dude's name? Douglas Carter. The Supreme Court they ordered him for a new trial, sent them back for a retrial. That stuff was like what 80 some odd pages. Like, that's long as out the wood. So
there's there's this one. This is the right response. There was 2 responses by the state. This one 6 pages, so it's a lot bigger.
Yeah.
All these documents are just, there's so many of them that, like I said, I was running late and I didn't have the time to organize them on my computer like I usually have. This one, just ready to go. Did not. Objection to defendant's untimely motion in limine to preclude the utilization of Article 1, Section 12 of the Utah Constitution. Yeah. All right. Yet again, I love the way the state writes, though, I will say. Defendant has ignored procedural rules in filing a motion regarding as a soon-to-be-held hearing that does not allow enough time for the motion to be fully briefed and for the court to adequately consider the motion. The court should not continue to continue or countenance the abuse of practice. Deny the motion is untimely. I mean, since 1995, Utah has allowed the prosecution to use reliable hearsay to establish probable cause at a preliminary hearing. That's what Article 1, Section 12 is. The Utah law, the hearsay. But if you have a problem with the Utah Constitution, take it up with the
Supreme Court. Or every preliminary hearing you ever do and every defendant you ever have should have the same motion. Yeah, I feel like she's doing this because it's a high profile. The majority of preliminary hearings are just like 2 hours. Now I understand why the judge.
No one generally cares about. 9 times out of 10, you will not hear anything about someone's preliminary hearing.
Most of the time, it's not even televised.
It has to be done. It's procedural. You won't really hear a lot of argument about it. You won't hear people wanting to delay it.
Yeah. For one thing, I watched a preliminary hearing in Michigan a couple of months ago, and they was cross-examination, but the judge, if they any objection to this exhibit or something, you hear the defense attorney or the attorney say, not for purposes of this hearing, Your Honor. So I'm like, it's routine.
So they asked for it to be denied because it's untimely. It's just the court has broad discretion to manage its docket. I think I like this judge
Tony
in the way he's handling the courtroom.
Yeah.
But I really think he has let this docket get out of control.
That's fair, yeah.
I don't know how else to.
Not a continuous has been granted.
It's almost like he's trying so hard not to do anything that's appealable that he's another one of those judges, like the judge in the Hales case, that they're trying so hard, in my opinion, to be fair that they end up being unfair and annoying. If that makes sense.
He's like a modern day Judge Ito, unlike Ito, who was media stuff for O.J. Simpson, was big on the media. This one seems like where Ito allowed a lot of delays and sidebars. This judge seemed like he type that would do something like that.
So they also filed a motion in limine to close portions of the preliminary hearing and seal exhibits. This is the objection to that.
Yeah, that's what argued at this latest hearing last week or week before last.
Yeah,
that, and there was a motion for sanctions that was argued. I believe they argued that there.
Yeah, and if you want to see that hearing in full, Flash Fan did stream it. A number of people did stream it. I am not going to stream it.
I guess I didn't stream it yet, but I probably will at some point. But yeah, it's YouTubers who like Andrew Burkhart and stuff like that.
It's a Saturday. I don't have the time to stream it today. Like, I'm trying to cover a lot of things, and like, just I don't have time to go through the documents and stream it at the same time. The last time I did a Tyler Robinson hearing, it ended up being like a 5-hour stream, and I'm like,
no, I saw it. I was like, you started like 2:00, then finished at like 6:37. I'm like, God,
Jesus. That was like, and half of it was sealed, and we were watching something else and going through documents, and it was like that is one of the reasons I decided to just do a monthly update, because I can't keep up with how many documents are being filed.
Because this case is unique. These cases, hearings like this, usually only take like these are like the initial stage. They usually take like 20 to 30 minutes. These things taking 4 or 5 hours, and
they're sealing part of it and not sealing part of it, and it's like you never know what part's gonna be sealed. Like it's just like
will have to be prepared. They talk about this preliminary hearing, because I know they probably gonna be portions that sealed. So I'm about to be ready to stream something else when it starts.
That's the thing. So let's do. And once again, here's and I'm going back to her Andrew Burkhart Substack to make sure that I have these in the correct order, because my brain gets fried.
And I don't know at the top of the document, I don't know if they put the like date is filed and what time it is. I don't think I've noticed that.
No, that's why I have to go all the way to the bottom.
Yeah. They're not like Florida when it'd be like filed 6/27/25.
Yeah, usually what I do is like here, I will change it to state. Like I'll put the date, I'll do 26/5/8.
Yeah.
And then so that way when I look at them in my folder, they are all in order. Right now it's just 26 and then whatever number I downloaded. So I'm having to go through state's response. And I'm not going to move it to a different folder because I don't want y'all to see what all folders I have. So because it gets a little messy. So she's pounding the table because that's all she has. Well, she took this case. She didn't have to take this case.
Yeah, so, she was pointed, but she could have said, "I don't think I'm ready for it." But I don't for her as much as I think she's fighting like her life is on the line as well, and you don't have to do that, at least at this portion.
She's trying to be. They're all trying to be like super lawyers, and it's like they want
to be the modern day dream team. What they try to do.
So, objection: defendant's motion is untimely, procedurally flawed because it does not allow time for the court to fully consider. Kind of the same thing they used last time. So, state has 14 days to respond to the defendant's motion filed May 1st, making the response due May 15th. Also, the defendant indicates he will be prepared to address specific witnesses the morning of and waive his opportunity to file relief. It's just, it gets so, they're trying to delay, and not only delay, but here's my other thing that I think they're trying to do. They're trying to make it where other people can't file responses, mainly the media.
Yeah.
I think that is what they are doing. They are filing these in an untimely manner so the state has time to respond, but the media does not have the time to put a that's just my personal opinion based on the fact that every state's response starts with this is untimely. I don't think they're doing it on accident.
Yeah.
I don't think they're doing it to mess with the state. I think they are doing it to mess with the media's lawyers and the media's response and the media's inability to timely file something to be heard or seen.
And I like how Nesta, she always comes and put these here. She be like, well, Your Honor, we're asking for continuance. We're not trying to delay. I'm like, nobody said anything about delaying. You bring it up. It means somebody said it to you. The judge didn't say you was untimely or you was trying to call the delay. You the one that brought it into your argument.
Here's the other thing that makes me think that. Defendant's motion fails to adequately identify the relief sought because the only relief they want, they can't actually say out loud. The relief they want is to not have cameras. So they're doing anything they can to delay, shift, untimely file things so the media doesn't have time to file their own objections or whatever and get their input in there for the judge to make a timely decision for the media. And I think this all has to do with the media. This has not, and she doesn't want hearsay in. This is the other thing that just came to me, and y'all can tell me I'm wrong. Feel free in the comment section to comment and tell me I'm wrong. I love that. She is not she. I say she, but they, because they are all doing it. Who knows who's actually writing these? They are all filing these motions to get hearsay out because they know the media will be there.
Yeah, it's definitely a media issue.
They never have a problem with hearsay being used in preliminary hearing that's not televised.
All these preliminary, even the preliminary hearings that are televised. Like I said, that one from Michigan a couple of months ago, that kid case. I need to check see what's going on with that. But it was all sorts of hearsay. Well, I was told this, I told it. No objections came. No objections.
I feel like everything they file all goes back to the media. They don't want hearsay, not because they think it's unconstitutional, because they don't want the media to hear about it.
Put stuff out there.
Because they don't want the media to hear things that may not be true, which in a way I kind of understand because it's hearsay, but like, this is not the way the court works, sweetheart. And yes, the media sucks. And this is one more reason why when reporting on things, you have to be able to tell people the difference between your opinion and what a fact is. Because I guarantee you, not Law and Crime or Court TV or anybody like that, but like if a regular podcaster who covers political stuff but never covers court cases hears this, doesn't understand that that's hearsay, doesn't understand that that is probable cause, may or may not be true, and runs with it. I can see that being an issue for them. I understand that, and I understand their side.
The problem with that is, though, if you televise the trial, you televise portions of it, and say the news media, they put a news clip out, well, he said this, and this is accurate because this person said this. A person who maybe in the chat section or whatever, I think the judge said this in this ruling for a camera, could come back and say, well, we watched the live stream of the court proceedings. That wasn't testified to. It didn't come out like that. So you can have misinformation cleared up by allowing cameras in it. That's I'm like, I don't know. I mean, some cases
I see their point. I just don't agree with it because that's not how shit works in this country. And you are only, and the other reason that I have a big problem with it is because they never have a problem with any of their other defendants that I guarantee you, none of them have filed this many motions to preclude cameras from any courtroom they've ever been in.
I don't know. I wonder what she's gonna do when the trial come up if it gets to trial, because she's not gonna be able to file motions to seal. Let's get to like kid witnesses, which I don't think there is any. It might be, but I don't know.
Yeah, you're not the only people who are a bit confused. The preliminary hearing typically evaluates the evidence presented by the prosecutor. The judge determines probable cause, and if the case moves forward, arguing manner seems odd.
Yeah,
I'm glad that people who are informed in the law are confused, because I am freaking confused.
It's not even a law issue. You watch enough preliminary hearings, enough trials, you know that like that's typically not.
Well, yes, but they are informed in the law, like lawyers in the family, like some people that actually do this for a living.
Yeah.
I'm glad y'all are confused, because that's what I keep going back to. It's a preliminary hearing. It's a preliminary hearing. Like, it's not the trial. It's a preliminary hearing. And she's arguing, I say she, because Kathy Nestor is the one who I'm like uber familiar with, because she did the Corey Richens trial. And that we all know how that went.
And Michael Burt, he was good. I don't know how he is now. Like I said, we haven't seen him in many decades. His cross-examination, he's methodic and stuff like that. But I don't know how he is with motion practice, because most of that stuff wasn't fit. Pre-trial hearing wasn't televised for the Menendez case. So I don't know how he was like pre-trial and stuff like that.
I mean, and this is one of the reasons that I'm not reading them word for word, because they are infuriating. Like, they are infuriating when you read them word for word, because like, this is what we got going on. We got that was, these are all this is just May. Defendant's motion in limine to close portions of preliminary hearing, seal exhibits. This is the objection to it. Ruling in order on defendant's motion to exclude still photographers, TV, cameras, and microphones from the courtroom in standing order. The judge basically kept it the same for the hearing. Don't show faces. Don't show computer screens.
Yeah.
Kept it the same.
Yeah, I think the cameras, I think he said the camera's in the angle where you can't film the defendant or something or the other.
Yeah, you can't film the defendant, and you can't zoom in on computer screens and things like that. And every time that they start a hearing, he brings up the people who are running the camera, the pool feed, and tells them. He goes over the standing decorum order. It's like he's trying to cover his butt. I get it. He's trying to make sure that nothing's appealable, that he's told everybody so that everybody's on the same page. I get it. It just seems excessive.
Yeah, I feel like another judge would be like, look, I ruled on this. They know what to do. If they violate it, there'll be consequences. Let's move forward.
Yeah, it's. I just and this is what I like. So there's a hearing minutes. I like going over these better than the actual hearing, because they're quick.
Yeah, because these hearings have been long. With it,
yes, these hearings are long.
These are trial day level hearings.
Yeah, these. So oral arguments for this were May 19th, which was said and done. But this one was May 12th. Just a. So the status of discovery, court addresses counsel on the motion to continue the preliminary hearing. Court will continue the preliminary hearing. Counsel agrees to July 6th, 7th, 8th, 9th, and 10th.
Yeah, that's also another issue. I'm like, now I understand why they set this stuff for a week. When preliminary hearing, you can only take like 2 to 3 hours.
Tops. I've seen preliminary hearings take an hour, hour and a half.
Only preliminary hearing I've seen that was long was, again, the O.J. Simpson case, but that was long, and they argued like motions to suppress and crap like that.
I feel like Kathy Nestor and company are trying to make this O.J. Simpson of the O.J. Simpson of.
That's why I say I feel like this trial's gonna drag. This trial gonna be at least.
I mean, we're 500 documents deep, and we're not even to the preliminary hearing yet. Like something just.
I don't
if
even
I were to cover this every day, this is all I would cover.
I just say
I would go nuts.
You would never be short content because they foul a lot of crap. This will become the Tyler Robin channel.
The motion in limine seems proper. Asking for evidence to keep from public eyes could result in tainted jury pool. I can understand that. It's just the amount that they're asking for. It's like they always ask for, like they've asked for all the documents to be sealed.
Yeah,
all of the documents. They asked for hearings to be sealed. They asked for not cameras in the courtroom.
They're asking to get rid of cameras in general. I can see they like, well, Your Honor, we want the preliminary hearing sealed. If they just said we only want the preliminary hearing sealed, okay, fine, cool. Because
if it was just a one-off, I would totally if it was just a one-off motion in limine asking for certain evidence to be sealed, totally. It's this my frustration at this point is not with what they're asking for anymore. It's them.
Yeah.
Because like in the Hales case, we've heard people talking about they're peppering the court with documents. This is what peppering the court with documents looks like right here.
Yeah. They file something every week, I believe.
Let's be honest here. This right here. Come on. There we go. Like this right here is what peppering the court with documents actually looks like. Like, oh, there we go. If I make the window smaller, the text gets bigger. Just, hey, Unreal Ozzy, how are you? How's the future? So it's like this right here is like, I think they asked for they had another motion in limine last month to seal things like
exhibits, I believe.
And we're trying to only keep it to May, but like just this is motion news media supplemental opposition motion to exclude cameras. Like it the preliminary hearing was supposed to be this month.
Yeah, I think it was supposed to be May 19th through the 25th or
18th through the 20th. And the fact that they set 4 days for a preliminary hearing just.
Yeah, this crap is going to be a week. That's why I'm like, now I understand why you're doing it. All the stuff the defense is acting. Well, the cross-examination is going to be a couple hours for one witness.
It's just hearing. They wanted to seal the hearing transcript. Not only seal the hearing, but seal the transcript. Like, if this was just a one-off thing,
like I said, I could see if she came this month and it hadn't been no motion to get rid of cameras, and she'd be like, well, Your Honor, we want to seal part of the preliminary hearing. All right, cool. Whatever. Go ahead, grant it.
It is just
but she asked for the media to be excluded every week.
Yes. Every time that there's anything filed, I feel like it's like their only thing that they can do. So
in the media, when they were arguing for back when they first argued, when the case first broke back in December, they was like, well, we might not want to cover every hearing, but we still want it to be transparent.
Yeah. And now I think they just want to be in the courtroom to piss off the defense.
Yeah, like now they're gonna want to cover every hearing because the more the defense trying to get them out, they gonna want to be there for everything.
It's just one of those situations where I'm like, and I say this all the time, but it's just frustrating having to repeat things. And it's like I say she, it's all of them. It's not just Kathy Nestor. Kathy Nestor is just the one that I know the most. She's the one I've actually seen. She's the one I've actually seen do it.
Yeah, because all the other ones.
Narrow their motion to presented evidence, but not sealing the preliminary seems a stretch. He has sealed portions of previous hearings before, but I've also never seen this many hearings before a preliminary hearing before.
No, it's usually from I don't know. Like I said,
like I said, not a lawyer, not a cop, never testified in anything.
Most of the prelims I saw from Michigan, and there was a hearing, the first appearance. You had a probable cause hearing, which are y'all ready for preliminary? Should we continue it? Should we keep it? Then they did a preliminary hearing, and that's it. It gets bound over. Usually like 2 or 3 hearings before a preliminary hearing. There's been
usually 20. You have your first appearance, your arraignment.
Yep.
And maybe one other one.
Yep. And for this case, there's been like 20, 30, 40 hearings before the preliminary hearing.
It just seems excessive. And I know this is a big case. And I know there's a lot. But the only one that I actually agreed with from the defense was, and I didn't agree with it in its entirety, but the premise I agreed with was the trying to get the prosecutor disqualified.
Yeah.
Not the whole office, but just that one person.
Yeah.
I think that one person, that one prosecutor whose daughter was there, should have stepped down or said, hey, don't come to me with any of this. My daughter was there. I need to stay out of this to maintain the appearance of.
I mean, trying to get rid of the entire office, I can understand that too, because there's been like 4 or 5 different Utah cases as of late that was televised. And most of the prosecutors we've seen in all those cases, usually in Provo, Utah, what it is, most of the prosecutors are from the Tyler Robinson case that we've seen so far in the 6 Utah cases that were televised this year alone.
And you know what I would be doing? Because I'm just this kind of person. So totally unrelated to the law, sort of. Athletes, what do they do when they're going up against somebody? They watch their opponents. They watch game tape.
Yep.
I would be
watching those trials. Because the case we just had, Megan Sunwall, which was the incident case in another poisoning case in Utah, had
What's with Utah lately? Utah is becoming the Florida of the West.
I know. They become more transparent because they didn't used to televise cases. So I'm like, that's why I also feel like the defense in this case is like, well, it become more transparent. They didn't used to. We want to go back to the old ways with in and around cameras. That's the only thing I could think of that they trying to do.
But like I said, I would be, because I'm the research. Like, I need to know what makes people tick. So I would be watching the behaviors, the objections that the prosecution likes to throw. And who knows, they might be doing this, but that's what I would be doing. What questions, what phrasing, do they like to use leading questions when they're not supposed to? Yeah. And then I would prep my witnesses for, hey, this is the stuff that this person might ask.
The female prosecutor was on that incident case, Lauren Hunt, I think that's her name. She was on the incident case. Chris Ballard, I think he's another prosecutor that's on the Robinson case, was on the Tracy Grish trial. So they've been around.
I mean, yeah, okay. High-profile cases will do that, but like most of the average person doesn't know that because they don't sit and watch Law and Crime on a daily basis like some people I know. Just saying. Just saying. And send me cases constantly like, hey, did you hear about this? Hey, did you hear about this? Hey, did you hear about this?
That's me. I see you.
That's not just you. That's a lot of people. And I don't mind it because
If it ever
there
gets too much,
are
it's like, hey, chill out, dude.
there are cases that I like to cover, but I don't have enough information about all of them. So
Yeah.
like I'll put it like we did that Legally F Friday one day where we did bad teachers. They
Oh,
all
yeah.
happen to be, most of them happen to be Florida teachers, but that's beside the point. That's a whole nother can of worms right there. It's Florida man at its finest. However,
I feel like Georgia is also becoming popular with cases.
yeah, 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 yeah. The insulin case was interesting. It got my CMA brain going for sure.
Interestingly enough, the jury, she was charged with aggravated, which was Utah version of first degree. They convicted her on man stuff. I don't know if I can say that word on it. So she got a lesser charge. They convicted her on. So I'm like, okay, that's interesting.
And this is the one that this is the one where the state's response to the motion to eliminate, and then they corrected it. So I had to make sure I got the right one because they corrected it. That's the weird part. So this is the I had to make sure that I got the right one because there were two filed on the same day. So we have a discovery deadline yet? No. Forensic thing is still out. Yes. If the hearing is pretty basic probable cause hearing, things will get interesting as the trial approaches with suppression motions.
This is going to be more than basic probable cause. Because why are they setting it for a week? I don't.
Yeah, if they have a week for a probable cause hearing, what is the trial going to be like?
It makes me think that Nesta and the defense team are going to object to every single thing. Because I'm like, why do you need a week for a
I do know that discovery keeps being handed over.
Yeah.
Every week there's more stuff. And
because in every motion that the defense filed, they say, as you know, Your Honor, as the court knows the discovery in the case of voluminous, they say that in nearly every motion they file.
Yeah. The one thing, let's see. Utah. I have it separated into states, but I have this one. So there's
motion to suppress that digital stuff. That's probably gonna come later on.
Yeah, there's been hearings on discovery and how much discovery there is. I was trying to look for one of the motions that I had that so
wow, Heidi, you are not a fan.
I'm looking through all the documents I have because okay, that's different case. There's so many different law enforcement agencies giving information to the prosecutor's office.
Yeah.
And the prosecutor's office is turning it over, but there is just so much, and they don't know when they're getting stuff either.
Yeah.
So it's law enforcement who is going through stuff, giving it to the prosecutors, and they're giving it, and the defense doesn't like it. And it's like, well,
they giving stuff to the police, giving stuff to the state. I mean, that's what they supposed to do. I mean, they'd be mad if. I mean, the state would be mad if somebody was giving the defense stuff and they wouldn't turn it over. Which can they? I know there's some stuff that doesn't have to be disclosed. That's the way I don't know because I'm not a lawyer, so I don't know how that works. But they'd be mad too, so I don't know why they get mad because cops is handing stuff over to the state.
So in this opposition to closed portions of the preliminary hearing, which would be inadmissible at trial. How do you know that the thing is like, how do you know what would be inadmissible at trial?
They don't know what the state has yet.
Huh?
I mean, they don't know what the state has yet, so that's why I'm like, how do they know it's going to be inadmissible? Half of the stuff might get admitted because it's just preliminary. They're just trying to prove probable cause. Some stuff might be excluded later down the line before it gets to trial.
And I will say though, like this is where voir dire, and if you suck at voir dire as a lawyer, sorry, like you got to get better Like, this is where your ability to interview and ask probative questions very quickly.
Yeah.
I feel like doctors, and maybe not doctors, but like therapy staff, this is where we excel, because I have to try to get to know somebody as quickly as possible and figure out who they are, what they're about, and try to infiltrate their personality, almost like a narcissist would, to get them to work with me when they don't like me.
Yeah, build rapport with them. There's some attorney. Every attorney don't have to be aggressive. I think that's Mark Garagos' strategy. Watched the interview he gave another California attorney, Hado Scott Peterson, years ago. He said his strategy is to his thing is to build rapport with the witness and then attack their credibility. Don't just come out swinging with everything you can.
Well, yeah, but in voir dire, you're talking to the jurors, so you need to be very good at getting information quickly out of people who you don't know.
Yeah.
Like the witnesses, you might not know them, but you know who's coming. Like, you have a witness list.
Yeah.
Like, you can research.
Yeah.
These jurors, you just get a juror questionnaire form, and you have to kind of elicit questions. You have to be very good at eliciting probative questions from very limited information.
Yeah.
And I feel like that is not a strong suit of a lot of lawyers.
Yeah.
I
know years ago, again, I take all my stuff.
That's not a strong suit of a lot of people. Let's put it that way.
From watching like classic cases from back in the 90s, early 2000s, they used to utilize jury consultants. They used to have consultants that be like, well, this juror will maybe be good. I don't know if they still do that or just the lawyers had to handle that.
Yeah, and Heidel said, yeah, that's like 5 minutes to a room with patient's laundry list of issues and meds for a 15-minute appointment. You gotta ask very probative, but you gotta make it seem like it's a conversation. Like, it's a skill. It's a skill set. And I don't know, because once again, I'm not a lawyer. But based on the voir dires or voir dires, however you want to pronounce it, I don't care. I probably pronounced it wrong. I don't care. So sue me.
How the judge in the Lori Vallow case said it, voir dire.
I've heard both. I don't know. Like I said, not a lawyer. I don't speak Latin. I can barely speak freaking English, let alone Latin. I can say pro hoc vice. I got that one. So, but it's a skill set, and it's a skill set where we in college are literally sat in front of people, almost like mock interviews. We are sat in front of our classmates, and we have to, it's therapeutic use of self is what we call it. Yeah. But we have to work on it in college, in front of our professors. We have to work on that skill. I don't think that is a skill that is taught like it is taught to us. Mm. And I think this is just where my background is different. And I look at stuff and I'm like, how do you not know that? How do you not know what to do? The same way a lawyer would look at me and go, how do you not know this? Because it's common sense to me. Building rapport. Yeah. Voir dire is like a building rapport session. You have to figure out information. You have to, but they're not going to tell you the correct information that you're looking for if you don't ask the right question. Yeah. And I just feel like therapy staff were taught that in college, where you might not be taught exactly. I mean, they're obviously taught about voir dire, but they're not taught the same way we are. Yeah. Yeah. I think it's just a college difference. But like, we literally have to go through and sit in front of people, and when we go and do our clinicals, that's one of the things that we're judged on.
I had all class in high school. Some law students came from the local university to teach for, I think, like 1 or 2 semesters. I wish I had paid attention. I wasn't interested in that part. I wish I had paid attention to that class, and I didn't. Now I'm ashamed that I didn't, because I would have known a lot more if I had.
April says that Britt speaks Florida cracker. I guess being born and raised in the deep south, that's a privilege. Oh my goodness. I don't know. I was born in Wisconsin, but raised all over the Midwest, and now I live in the deep south. So, we're just We're all over.
Did another Wisconsin case happen? I need to see what area that is. Something whitewash, Wisconsin, or something or the other.
Whitewater?
Whitewater, yeah.
Whitewash.
I don't know. I looked at it last night. I didn't pay attention to how it was spelled. I was like, oh, whitewash? Wisconsin? Okay, that's different.
The defendant has failed to demonstrate that the public and media's access to the preliminary hearing poses a realistic likelihood of prejudice to his right to a fair trial. I mean, because all they've kept saying is they've repeated the same thing is that it's going to interfere with his right to a fair trial, but they never actually said how.
Yeah, they worded so many different ways, but they never go. That's why I think the state was like, yeah, they're vague. I think that was one of the things that actually really
She's not wrong. She's not wrong. Just okay. In the present case, defendant's motion is legally deficient because it fails to address the two elements that must be analyzed under the case law cited, and thus fails to satisfy the standard for closing the preliminary hearing or even portions. First, defendant has not identified the specific testimony or exhibits he seeks to suppress. That seems like an obvious, like, and what I can appreciate about the prosecutors here is they get straight to the point.
Yeah.
They're like, hey, in the present case, here's my case law. However, how it applies here.
I feel like the defense team, they're just like, well, this is what we want. The case law says this. The Supreme Court said this. And the Constitution said this. It's not supposed to be done this way. I'm like, just say.
But that has nothing to do with your case. How does that apply? It's one thing, see, and this is just me spouting off and being sassy, but it's one thing to cite a whole bunch of case law that may apply to your case and that may prove your point. It's another thing to actually describe how that case law proves your point. You can cite as much case law. You can cite as many articles. Like I can cite when I do ETM streams, I can cite as much research as I want. But how that research actually applies to what the hell I'm talking about and why it's important to what the hell I'm talking about is a skill set.
Yeah.
Some people have it, some people don't. And it's a reason why there are a lot of, like, there's a reason why it, just like in medicine, how there's specialties and people are good at one thing and may not be good at another. Like a cardiologist, you put a cardiologist with a neuro patient and they're going to go, what the hell? You put a neurologist or a neurosurgeon with a cardiac problem and they're going to be like, what the hell? You put a lawyer who works on DUI cases with a murder trial, Carly Gregg. It's not that they're a bad lawyer. They just might not be good at that.
Yeah,
but that's all we see. So they look like a bad lawyer. Sometimes you got to stick to your strong suits. Hey, Dad, whitewash. Yeah, whitewater.
I don't know that from Wisconsin. Your parents,
Yeah, whitewater. He's from DC.
Your parents make fun of me because I don't know Wisconsin. All I know about Wisconsin is cheese. and cheeseburgers, which people still trying to get me to try, but I don't know because it's cottage cheese.
It's not that you might be bad at one thing, but like it's even therapists get roped into this. Like you have someone who is on a cardiac floor they get a cardiac patient who had a stroke, and all of a sudden they're like, oh my God, I don't know what to do with this person because I haven't worked with a stroke patient in 10 years or 5 years or however. And they're like out of their element. They're not a bad therapist. They're just really good at what they're good at. And they just don't know what they don't know. Well, I'm assuming it's the same with lawyers. You get a whole bunch of education in college, and then you go into a certain area of law, whether it be personal injury, contract law, whatever the case may be. And then when you try something different, sometimes it doesn't always work out because skill fade. Skill fade. It depends on the cardiologist. Are they the plumber or the electrician? The electrician has a better chance of understanding their neurology patient. Strokes have more to do with plumbing. True. I follow a neurosurgeon on Instagram, and or on YouTube actually. She was talking about being on a plane, and they asked for a doctor. She's a neurosurgeon. The patient was in SVTs, supraventricular tachycardia, and she's like, good thing there was a nurse on board that handled it because I got nothing.
Anyway, I need to see that case. This is a Florida case where the doctor is accused of unaliving because apparently he removed the wrong organ or something when he's supposed to be. What was he supposed to be removing? Can't remember what he supposed to be.
I can't remember. But
Like,
that said, Silver Fox said they still shouldn't practice outside their scope of practice. Yeah, and I think that's another thing because the law, just like medicine, is so big, and I think that's where they're comparable. Is sometimes I laugh at people, like I laugh at Bridget Todd because she would trying a murder case was laughable. However, she might be really good at the area of law that she actually practices.
Oh yeah,
she might be amazing, but a personal injury and a DUI lawyer trying a unaliving case for the first time.
Yeah, I don't know what possession today. I'm going to take a first.
I don't know what the hell that was about.
And
and I know we're getting off topic, but that's what we do here. But it's like maybe he's Kevin Camp's really good at trying. I think Kevin Camp was the personal injury.
I think so. Yeah.
Bridget was the DUI.
Yeah.
They might be really good at doing what they do, really good. But I just feel like an unaliving case is a very specific area. But also, you take someone who's good at unaliving trials and put them on a DUI case or a class action lawsuit or a malpractice case, and they're going to be like, I don't understand what the hell I'm doing right now.
Or like a James Owens decided to take Sarah Boone. He was he's a lawyer from the 80s.
And his practice isn't even open anymore.
Oh, he gone? Oh.
The state's reliance on 1102 and rules of evidence admit evidence at the preliminary hearing will not jeopardize the defendant's right to a fair trial. Defendant has failed to properly identify particular concerns with the evidence. Yeah, they just blanketed like this is why. They never actually state specifics, and I like reason. I like to know why. Why? You say it's not going to give him a fair trial. Why? And just eyes on the trial may not be sufficient. I need the why, because there's voir dire for a reason. Voir dire exists for a reason so that you can get rid of a tainted jury pool. And I honestly think more people that have eyes on this case don't live in Utah.
I hope so, because it's gonna be hard to find jurors. Yeah, the way this case is going.
It is the perpetual 2-year-old. Why? Yes, that I am. Ask my parents. I'm pretty sure why and technically were the 2 words that they ever regret teaching me how to say.
The word my mom probably regretted me saying was, well, see, what had happened was I was famous for that, to try to get out of stuff.
You having a straight head on stream. What? Like, yep. See? One of the 2 parents agrees. And the word no. Yeah.
My little cousin, when she was little, was famous for it.
I was the kind of kid that
she throw stuff.
I was the kid that took apart shit to see why it worked and couldn't put it back together. That was me. That's me right there. The state provided defendant with preliminary hearing witness and exhibit list on April 3rd. And updated witnesses on May 6th, yet defendant has not identified with particularity the specific portions of the preliminary hearing that he believes should be closed or particular exhibits he believes should be sealed. That's a really good point that I didn't take into consideration. They gave them exhibits and witness lists, and you just want it all sealed. And I think they're being you mean destroyed. No comment, sir.
You would like my little cousin. She'd break the remote.
No, I wouldn't see what I consider breaking is like this. Like smashing my phone. That's breaking. I would like unscrew it.
Oh, you was the
Like,
little.
I would like take it apart
You
and just not be able to figure out how to get back together.
You want to be the little mechanic that takes stuff apart.
Yeah. Like there's a difference in my world that like breaking it is like throwing it and breaking it. Taking it apart is like, here's the little headphones. Like there's a screw here. Like taking these off, unscrewing it, popping the like see how it works internally, and then just not being able to put the parts back together.
My little cousin, she used to flush things. She flushed my earphones. I was so mad at her.
I figured out that a pair of wired, wireless but wired together Beats can be washed and dried and still worked.
Oh wow!
When she tried to rebuild something, she would have leftover parts. Y'all are mean.
You guys, I'm an inventor.
Y'all are mean. Yep, my parents throwing me under the bus.
That's what parents do. You'd be doing the same thing.
I would say if you want me to read another one of your comments, put it in the super chat, but I don't because YouTube takes 30%. Like, it's not enough for defense to say that it will identify those details at the oral argument on the motion. That approach does not give the state, the media, and the court sufficient time to consider and address the claims. I mean, that's to me that is a reason why this should be denied. It's because we just don't. We're not mean. We're just telling you the truth. I use that all the time. I'm not being mean. I'm just telling you the truth.
I remember I got in trouble. And my mom was weighing me out. She like, you know how parents say they weigh you out. They like, this gonna hurt me more than it hurts you. And I stopped crying. I looked at her. I said, I don't see you crying. She busted out bad, but I got it 10 times worse. But she's like, you boy.
Malin asked me, how did I talk to text in Mo's chat the other day? I want to learn. On my phone, I have a little microphone button on the keyboard, and I just hit that and talk. But I have to use I have to say, how was your day? ? Like I have to actually spell it out.
Yeah, you can talk to your phone. I don't like it because it always misinterprets my words and puts. I'm like, that is not what I said.
So the state previously provided copies of exhibits to both the defense and the court for inspection and standards prepared to address each exhibit at oral arguments on defendant's motion. It seems like the state had.
Dang. Your parents are going on you right now.
And people wonder why I act the way I do. Look at my parents' personalities. And snark. And this is just in the chat. Can you imagine what they're like in real life? I don't feel free to time out my parents if they get snarky. Oh my god. Oh my Jesus. Welcome to therapy time with Squid and her parents.
My parents will be doing well. My mom, because my dad wasn't really active, but my mom would have been doing the same thing. If my mom could be in YouTube chat, woo, I'd be getting embarrassed like I don't know what.
Oh my goodness. Welcome to therapy with Squid and her parents. Oh my goodness. Gotta love it.
I can imagine my mom right now. She put a Squid Pro Club. Did Flash ever tell you about the time he tried to eat a battery?
All right, getting back to this. This will be our last motions. We're at 2 hours. Defendant has not overcome the legal presumption that electronic media coverage is permitted in preliminary hearings. Utah Code of Judicial Administration, Rule 4-401.01 outlines uniform standards and procedures for electronic media coverage of court proceedings. So that section creates a presumption electronic media coverage by news reporters shall be permitted in public proceedings where predominant purpose of coverage is journalism or dissemination of news to the public. And honestly, I would rather see it live than have people in the courtroom and have to base my interpretation on their.
They saw, yeah. Or a good medium would be, if they don't want to see it, just be like, okay, what you can do is record it and release it later on, so the people can see it.
Exactly. Like it.
That way, if there is a sealed exhibit, the media can edit that part out.
The preliminary hearing is a public proceeding, as all court cases are. Yeah. Consequently, the media has a right to be present and to report on the hearing. I mean, they go into case law. The court should restrict the public and the media from physically inspecting or copying the preliminary hearing exhibits, but allow the media to report on what occurs at the hearing. Yeah. Totally get that. Like, I agree. Like, we don't need to see everything.
Yeah, don't give it to the public for dissemination. But
no, like, just put it on. If there's like a projector or a screen, don't show us that.
Yeah, totally judges do it all the time. They say when it's like graphic evidence, the media is directed not to film this because it's graphic nature or because it's sealed or something like that. Just be like, don't show it.
So they say some exhibits include the autopsy report, the medical examiner's photos, and tissue bone fragments. This is stuff that I kind of want to see, but not from a morbid, like, I need to see stuff, but from my background and just like liking that stuff. Like, I always joke in people's chats when they're watching and stuff, and there's a doctor, and I'm like, "Ooh, I love it when people speak anatomy to me." Like, you know what I mean? I am that kind of person. Like, I go geek when people speak anatomy, physiology, and start going over like the medical stuff. That's
why with some of the cases that we come in court watching, Heidel will be there, and they be like, medical. I'm like, okay, I need you to explain it to me because that stuff go way over my head. I don't understand forensics and all that.
And that's the stuff that I love. I love that. That's the stuff.
God dang it.
Imagine a mother-in-law's. Oh, you want to talk mother-in-laws? You want to talk mother-in-laws? My mother-in-law apologized to my sister-in-law, my man's brother's wife, my brother-in-law's wife, by saying, "I'm sorry, that's not your fault. That's just the way God made you."
Oh my God.
So there's that.
I had to think you a song that came out in the 60s about mother-in-laws by A. Doe called Mother-in-Law.
So while the court reaffirmed the press's right to attend preliminary hearings and report all that occurs there, it clarified that the First Amendment does not grant a presumptive right to physically inspect or copy exhibits from those hearings. That totally makes sense. I think that's what they're intentionally misinterpreting. The court also held that the public and the media are not entitled under Utah Constitution to inspect preliminary hearing exhibits. They're not entitled to inspect exhibits at all. Yeah, even in a trial. Like,
in the
where
trial.
are these people real lawyers?
I mean, okay, in some cases, they have sent exhibits to, I think, the Microsoft executive case. I think the media got sent like the investigation report and stuff like that.
Yeah, because it was leaked. But under normal circumstances, the media doesn't ever get to inspect.
Yeah.
Like, I'm like, are these people real lawyers? Where are they coming up with this bullcrap? Because Heidel, that's like half the day you deserve. So I just here, none of the state's proposed evidence is speculative, inflammatory, or inaccurate. Although the videos of the victim being pew-pewed are sensitive, and again, there's nothing to suggest that substance of the evidence is inadmissible. Moreover, the evidence does not involve words that I can't say. However, because some exhibits are likely to be used at a subsequent trial, the public and media should be restricted from physically examining or copying them in light of the vast amount of pretrial publicity in this case. Allowing the public or media to physically inspect or copy exhibits at this stage may disrupt the efficient performance of justice. Well, duh. Like,
They don't do that anyway.
And I'm not seeing do we not have common sense anymore? Like, I understand that you have to put it in an argument because if it's not in the record, you literally didn't say it. Okay, this is going to sound completely stupid, but in my twisted mind, it makes sense. Writing a legal document is kind of like talking to ChatGPT. In order to get what you want out of it, you have to put exactly what you mean.
Oh, yeah, definitely.
You have to put exactly what you want and exactly what you don't want. So they have to do, but it's like sometimes you just look at it and you're like, duh, have we not have precedent where we don't ever get to inspect shit? Yeah. Judges most oftentimes when there's videos or pictures being shown do not have those on camera and tell the pool feed operator to not show those. That's normal.
I'm reading the Menendez brothers retrial transfer because he didn't allow judge didn't allow camera for the second trial. And one of the news media people went in there. I'm not a big fan of that judge, but one of the news media's people went and like, well, Your Honor, we want to know, can we copy exhibits and can we take the exhibits and put it on the news later on and can we inspect it and stuff like that? And just like, no, because you're not a party to this case. The only people I had before me is lawyers. No, and don't hand anything out. So I'm like, they never allowed that. I don't know what they're talking about. Don't allow them to copy. They never do that anyway. They can't do it.
So they do have this is just the last thing we'll cover really quickly. They do have a reply. Exhibits classified as private, protected, or safeguard. This is from the defense. The state also notes in its objection that it intends to offer exhibits to the court, but the exhibits are typically not published to the courtroom gallery. Defense agrees this best approach to avoid possible duplication and inspection of the exhibits through a video recording or live stream of the hearing. What? Duh. So medical, psychiatric, or psychological records, photograph, film, or video of a crime victim. Seems like common sense, and this didn't require a reply.
I'm like, they don't do that anyway.
That's what which is one of the reasons I would like to compare these documents to other documents that they have written from other cases they have tried that have been publicized.
I want to see if I can find a Corey Richards file and I'll send it to you at some point to see.
That would be interesting to me to see if Kathy Nestor had argued any of this in that case, because that case was also highly public. And if she didn't, then that tells me that this is all for show, which is one of the things that I think this is all for. This is not for actual purpose. This is not purposeful. This is to create drama where there should be none.
Yeah.
Like,
I'm like, most of this stuff don't take a year to get to preliminary hearing. This is crazy. It's almost he was arrested in October. We about what? Look at that, 5 months away from it. October, September, I think.
Heidel, I always tell people I'm not going to pray for them. I'm going to pray for their family because their family has to deal with them on a daily basis. I get to shut off my computer and not worry about it. Or I get to leave the store and not have to ever see you again. Your family has to deal with you every day. Bless your heart, princess. But also, when I hear someone say "bless your heart," I'm like, we need context. Like, are we blessing it in a good way?
I'm like, yeah, that could be interpreted multiple ways.
That's like telling someone to go F themselves. It's like, are we saying it in a joking, like, haha?
I think you were probably trolling with that comment, so I know that could be used in different ways.
Around here, it's cotton picking. We have cotton here. It's
you were
slowly getting anywhere.
You were Southern Georgia. That makes sense.
It's like one of those situations where, like, I saw a video of someone who went to Alabama and then complained that their Airbnb was across the street from a cotton field, and I'm like,
"Then you was
to Alabama.
You was fat. This is Alabama. You want
to Alabama?
Like,
welcome to Alabama. It was a real TikTok too.
Like, I would be surprised if you didn't see any out there.
Exactly. And it like gave her PTSD from I don't I should have asked you because this is a question I have, because I am not obviously I'm pale as shit. Does seeing a cotton field traumatize you?
No, I mean, this my ancestors from centuries ago did that. Now I know it's used for like material. What is it used for? Used for they grow it for something. I can't remember what they grow it for. But yeah, no, it's
okay.
Yeah, no.
Just had to ask because I was genuinely curious.
No,
I was like, is it a thing, or am I laughing at her for no reason?
No, this like I said in Alabama, I'd be surprised if she didn't see that.
Look at this footnote. Footnote 3. Well, Mr. Robinson has already been charged with the murder or aggravated murder. 2 separate criminal investigations are underway and will continue at least through the conclusion of his trial. First, government agencies at federal, state, and local levels continue to investigate the circumstances surrounding the pew-pewing September 10th of 2025 and his alleged role. It's well understood that criminal investigations in a complex matter do not conclude with the filing of a criminal charge, but we know. But look at this is their whole like.
Jeez.
This is all a footnote.
Jeez, that's crazy. That could be
emotion. That's one footnote.
That could be emotion in of itself.
The volume of vitriol of both formal and informal media coverage. Hi, informal media coverage. Bless your hearts. Kathy Nestor, I don't like you. Richard Novak, I don't like you.
I'm serious. One day I see a motion to preclude Cameron. Everybody, we want to preclude Cameron from the courtroom because of a YouTuber named Squid Pro Quo has been covering this case. I'm gonna laugh so hard.
I'm pretty sure all attorneys and judges realize keep probable cause hearings, submitted evidence confidential. A mistrial, if leaked, would be devastating. Defense inspection prior, long shot, but maybe. I have watched enough preliminary hearings and just trials in general. They keep a lot of that stuff private, away from cameras anyway.
They don't show that stuff.
They don't show a lot of that stuff.
They'll show the witness something, and they don't.
Sometimes in trials, it has happened where you're like, "Oh my God, can't show that on YouTube."
Yeah, like the Edric Faust stuff when she allowed this doggone witness to put her social security number out there on the air. Like, what is wrong with you? But
yeah, for the most part, if there's stuff on a projector, they don't really show it.
Well, oftentimes the media doesn't even have to be told. They know that. They don't show it out of respect.
And I'm sure if the judge added that to his standing decorum order, hey, do not show any of these on camera.
They're not going to violate it because that means them getting kicked out of the courtroom.
Exactly. So, like, I feel like this should just be accomplished with a lot less paperwork. So they go into what other exhibits, business and personal address, email addresses. Like, well, yeah, they don't really
put that out there.
Yeah, they don't put that out there anyway. Like,
it
begs the question of who's actually writing this, because all of these lawyers have supposedly dealt with trials that have been public before, and this has never been an issue. So why is it
been an attorney
now
since 92? She should know better. She should know. She's been attorney for decades at this point.
It's just like I said, I will repeat this. Not a lawyer, never claimed to be one, don't want to be one. However, like, duh. This is not stuff that's shown anyway. Yes, overstating what's already excluded.
Yeah.
Like, and they wrote 15 pages of this. which in their defense, I can see the state did ask them to clarify.
Yeah.
So, but at the same time, they're adding shit that doesn't need to be.
And the law enforcement, I'm just nitpicking, but that's a Utah thing. They always went to Utah.
The request for prior inspection, though, well, I would just say don't allow the media to inspect. Like, they don't allow the media to inspect. It's just obviously it's worked for other trials where the media doesn't get to inspect and the defense and the prosecution both do.
Yeah. I mean, they've been televising cases since 1991.
But this is all stuff they already have. This is all stuff the defense already has and that the prosecution said that they would be using. So yeah. I don't know what they're wanting to inspect because they already have it. Yeah. So just don't show it on camera. It seems like a logical. I mean, just seems like a logical thing. But they want things not to be shown that are the media already has. Yep. We already have photos of the rounds from apartments.
Yeah, because
we already have some text messages. We already have the ATF. We already have one of the ATF reports.
Yeah.
DNA report, rifle, and cartridges. Like, there's certain things that, like, I see the point. They're arguing things that, in my opinion, don't need to be argued because they're non-issues. Add it to the standing decorum order. Do not show the exhibits on camera. Seems like a pretty logical thing. Tell the pool feed operators not to show it on camera. Yeah. And if they do, they're screwed. Yeah. And then move on from there.
Yeah.
I mean, there just seems like a lot of stuff that's just...
It's general practice. Like I said, the media have been doing this since 1991.
Yeah, this is not the media's first day. But I have noticed other media entities... I have noticed that other media entities, when they've been operating cameras in other courtrooms, have started to follow the way they do it here, where they don't show the defendant's face.
Yeah.
I have found that quite interesting.
It's general practice. They're trying to get away from that. They used to do that years ago. They zoom in on the defendant. And
I just wish they'd stop showing the family.
Yeah.
Because, like, show the defendant, fine. They're the one accused. Don't show the family.
Yeah.
They had nothing to do with this.
Yeah.
Yeah, we already know the recovered rifle was the grandfather's rifle. There's that, too. I mean, there's so much.
That's why I said, I kind of, in the back of my head, I taunt and laugh at the defense. But like in the back of my head, I'm like, yeah, maybe they're asking for cameras to be excluded. It's not the worst thing to have, because I'm like, I don't know how they're gonna find a jury for this case. But at the same time, like transparency, you need to be transparent so it's misinformation isn't spread.
Yeah, I feel like you can be transparent without being. You can be transparent without being like a douchebag.
Yeah.
I don't know how better else to like, you know. But there are, to me, they're wasting time. They're wasting the courts and the state's time by arguing issues that aren't issues. They've never been issues for any of these lawyers before in any other cases.
And
why are they issues here?
And it's a death penalty case. This stuff costs money to. I'm sure it cost the state millions of dollars, and they just dragging the crap out.
I feel like they're dragging crap out on purpose because they know they don't have a case, and they know that there's a good chance their client may end up on the unaliving row.
Yeah.
And I think they are just trying to keep him alive as long as possible. Not that this is not Texas. They don't put in an express lane, you know? So there will be appeals and appeals and appeals. Do you suppose they want to drag it out and hope they get a plea deal? I don't know, but I don't think there will ever be a plea deal in this case.
A case of this magnitude, I think the state, but no, we're not giving a plea deal.
I think there's too much evidence for a plea deal. And the fact the rifle that was allegedly used, being his grandfather's rifle, and his dad and his mom and dad basically identifying him in the video being another problem. So,
I mean, could it be a plea deal? Theoretically, do I think it will be? No.
Theoretically, anything can become a plea deal. However, in theory, it's possible. I just don't believe that it will, because I think the state has too much. Do I think it will be do I think it will, if anything, I think it will be a Brian Kohberger plead, and you get life and take
to get the capital penalty off the table.
Yeah, if anything, that is what I think will be the deal. Do I think it'll happen? No, because I think his lawyers are too stupid to ever let him do that. If he did do this,
this is a very Kohberger-esque trial with digital evidence, and I think Kohberger took a long time to go to bed. I don't even know they had a preliminary here for Kohberger, but it took like years before with even theoretically close to trial when they're like, yeah, he just plead guilty and getting life.
Yeah, but he drug it out and made the family suffer.
Yeah,
interesting how that one worked, huh? I don't think he did that for himself. I think he did that to make the family suffer.
Yeah.
Because he's just that kind of a person.
It's kind of same with Rex Heuermann, how do you pronounce his name? The guy in New York, he took a plea deal.
I didn't say what, if anything. I said if anything. There's a difference. I said if anything happens, it will be this. Not what if anything. Yeah, and never can appeal type. Well, that's an interesting one. I don't think his lawyers will let him do that. But if you plead guilty, I don't see you being able to appeal very easily.
Yeah, Kohberger can't appeal, and neither can Rex Heuermann, because they all pleaded. They took plea deals. They got severe punishments. Heuermann probably did it to make the family just drag stuff out and make them go to the worst stuff. But yeah.
But on that note, do you have any final thoughts? Because we've been at this over 2 hours, almost 2.5 hours, and I got to go.
No, it's just interesting case to see. You had to see what the court's going to rule with this sealing preliminary hearing. I hope he doesn't do it, but who knows, man. I can still rather see the parts of the argument. I don't think I agree with all of it, but
it's the last thing in was the request and order for electronic media coverage, which is just the same thing as it always is. Not worth.
They must get a hearing coming up. Actually, I think the preliminary isn't that for June, so I think that'd be soon.
July.
Oh, July. Okay. So
yeah, it's delay. Almost a year.
Yeah.
10 months before the.
Is
That is appointed with the Florida Supreme Court had issued an execution stay on the police officer James Duckett, convicted of. I think he.
Ooh. Wow. That is very the Sandra Birchmore type situation.
Doesn't seem like a Sandra Birchmore case. I gotta write that. I think he I don't know. He might have mentioned that to me. I think he mentioned something to like. Don't, Jeff, if you're listening, don't be mad at me, but I can't remember. It's been a lot on my brain lately. But I'm going to write that name down. And if we want to have a rage stream, that's what I'll that'll be it. Oh. All right. That'll be a rage stream. We need to that'll be a wine and rage stream. All right. Well, we will do another one of these at the end of June because this is about all I can handle of this case because there is so much and there's just so much that makes you go, why are we doing this?
I guarantee you there will be not more before the preliminary hearing shows up.
And the big question, will they get it delayed again?
Yeah, that's also a possibility, a high possibility. No,
or will they file to get it delayed again? There's my big question.
Yeah, most likely.
Like it's, it's one of those situations where I just feel like they're doing this intentionally and not in a good way. Like there's no good reason for what they're doing.
Yeah.
That I just don't. You ever look at stuff and you just don't understand why people act the way they do. And that goes from everybody to lawyers, doctors, politicians. I just sometimes look at people and I'm like, why did you ever think that was a good idea? Like, I just don't know. Anyway, I'm going to see if there's anybody live on YouTube that we can... So, Broken Baker or just Jay Hip? Y'all let me know which one you want. Let's go to Just Jay. I went to Baker last time. Let's go to Just Jay this time. So y'all have a great day. Tell Jay that I said hi. Don't have him grift for me because how dare he make money off of me. That was funny yesterday though. He's like, don't worry, I'll grift for I'll grift for you. No, because that's your money. Broken Hip. Oh my God. If Broken Baker and Just Jay Hip knew each other, the Broken Hip Show. Y'all have a great day.
It's great. Thanks for having me as always.
No problem. I'm glad you could make it. I'm tomorrow on this channel. We are going through tomorrow night. We are on the other channel. We have our Sunday Night Live. Then Monday we are talking Anna Kettner on this channel. So Anna Kettner.
I did think you his bail hearing, I think, transcript.
Yeah. We'll go through some of the updated documents in that because there's just a lot. Just a lot. There's just a lot going on in a lot of cases. Did you hear Judge Hannah Dugan, or former Judge Hannah Dugan? Has oral arguments for getting a new trial.
Oh wow. Isn't that the Wisconsin one?
Yep.
Yeah.
Yep, yeah. That's her. That's her. So y'all tell Jay I said hi. Go show some love, hit the like button, and I will see you guys on the next one. Bye.